Hi, everybody, and welcome to Lawyers and Friends. Today's installment is getting some action with third-party actions. And please notice that's Dr. Sue's, not Dr. Seuss, because we don't want to be sued. Today, we're going to be talking about third parties, but before we get started, I just wanted to introduce myself. I'm M.A.D. 1, Melissa A, and this is
M.A.D. 2, Melanie A. Daly.
And we're doing a Dr. Seuss theme. Just to get through some required legal announcements before we get started, that the following should be considered attorney advertising, and prior results do not guarantee a similar outcome. And also, nothing today should be construed to constitute an attorney-client relationship. If you have some questions regarding third-party actions about a specific case, we'd be happy to talk to you about them. So let's get started. There's a couple of things that I want people to come away with from today's presentation, because we're going to build on what you learned today, hopefully, for our next presentation, which will be part 2 in March. So let's get started. Thank you. Compensation, workers' compensation, and is an employee's exclusive remedy against their employer for injuries that are sustained at work. And please notice that I put an emphasis on employer there, because we're going to see in a couple of minutes that compensation is not an employee's exclusive remedy against a third-party tortfeasor. This is as a result of what's been described as the grand bargain between employers and employees, where a worker is given a right to benefits automatically without regard to fault, and employers are protected from liability actions by their employees against them. So the grand bargain is that the employee automatically gets benefits for injuries that occur at work, and the employer is protected from large judgments as a result of pain and suffering. This workers' compensation as an employee's exclusive remedy is found in Section 11 of the Workers' Compensation Statute. There are a couple of exceptions to the exclusivity rule, and if you think about the grand bargain, the exceptions actually make sense. The first is an intentional tort. So if I punched Melanie in the nose right now, she wouldn't have to elect to take workers' compensation as a result of the injury that she sustained. She could sue me in tort for the intentional tort. Mm-hmm. And so that's if an employer intentionally injures their employee, then the employee isn't limited to that grand bargain, because it's no longer considered a no-fault statute. There's actually a fault, and that's the employer's. And then, similarly, an employer is not entitled to the protections of the grand bargain if they fail to secure workers' compensation coverage for their employees under Section 50. So, in all cases, the employee or the employer is protected from direct suit by an employee against the employer unless the employer intentionally injures their employee or they fail to secure coverage for them.
So when they fail to secure coverage, then the unemployed insurance employer's fund takes over as carrier.
That's true. So if an employer doesn't have workers' compensation coverage, there's a statutory fund that's created called the UEF. We have several of those cases here at the firm where we're defending employers who have been called for New York workers' compensation claims, and they don't have coverage. And sometimes it's an innocent mistake, and the injury just happened to be in New York, mm-hmm. and that confers jurisdiction on an employer. And in other instances, it's expensive to have workers' compensation coverage, and the employer makes a decision not to obtain the coverage, and that gets them in big trouble. Don't do that. Okay, so we've talked about the workers' compensation as an employee's exclusive right as against their employer, with those two exceptions. But workers' compensation is not the only avenue that an employee could have for obtaining money or compensation. So let's think about compensation as being monetary recovery as opposed to workers' compensation. It's not the only avenue that an employee has for obtaining money as a result of an injury that happens at work. Section 29, in addition to recognizing that there's a right to workers' compensation as a result of an injury that occurs at work, by the employee against their employer, also says that if an employee is injured as a result of the negligence of a third party, they can bring an action against the negligent third party to recover benefits. So there are two avenues to obtain money as a result of an injury that occurs at work when there's a negligent third party. Mm-hmm. One is against the employer for workers' comp, and the other is for a monetary judgment in civil court against a negligent tortfeasor. Slide. The employer is what is known as subrogated to the employee's right to bring the action against a negligent tortfeasor under Section 29(2) of the Workers' Compensation Statute. And that sounds complicated, but it's really not. What it just means is that if the employee doesn't pursue an action that they have against a negligent third party, the employer can bring that action. And that's because the employer, if they can bring an action successfully on behalf of their employee against another party who's really the cause of the fact that their employee was injured at work, then they should be able to bring that action. Normally, if there is a possible recovery, an employee is going to find an attorney to bring an action against a negligent tortfeasor. But if for some reason the employee does not bring that action, then the employer is subrogated to or stands in the shoes of the employee and has a right to bring that action themselves.
And there is a time limit for the employee to bring the action, correct? Before it is subrogated.
Correct. So the statute has certain requirements that have to be met before the employer can stand in the employee's shoes and bring the action on the employee's behalf. And it's 6 months from the date of injury. There have to be certain notices that have to be provided to the employee. In other words, the employer telling the employee, like, we intend upon bringing this action. And of course, you always have to comply with the statute of limitations. Okay, so now we're going to get to the interactive part of today's presentation. So hopefully everybody has a smartphone with them. So what we would like you to do is text the phrase Melissa Day 929 to the text number 22333. Can I have the next slide, please? Because there will be instructions on how to do this. We're going to ask you a question that we would like you to answer remotely by texting the phrase Melissa Day 929 to the number 22333. If any of you have, and I'm sure some of you have attended a live presentation that we've done at the Buffalo Claims Association E-Day, you're familiar with this technology. We are going to ask you questions during this presentation, and we would like you to submit your answers. So we're going to give everybody a minute to text the phrase Melissa Day 929 to the number 22333. That will get you basically signed up for the poll that we're conducting right now, or for the interactive part of our process. And you'll be able to answer the questions that we're going to pose to you throughout this presentation, mostly to make sure you're not sleeping. Okay, so question number one. To subrogate means what? A, to put another's needs first.
B, to crawl under an opening in a fence.
C, to put in place of another, to substitute for another.
Or D, to cause a sandwich-related scandal.
Okay, so please, once you've signed up for the poll and texted Melissa Day 929 to number 22333, you should get an acknowledgement that you're participating in the poll. And then all you have to do is send your answer, A, B, C, or D, to the same number, 22333. So please do that now. Okay, so let's see what everybody picked. I think it's to cause a sandwich-related scandal.
Me too.
Oh, look at almost everybody got it correct. Okay, I think that somebody appreciated to crawl under an opening in a fence.
I was hoping for at least one D.
Yes, the answer is C, to put in place of another or to substitute for another. So you can think of it as somebody standing in somebody else's shoes. So the employer stands in the employee's shoes if the employee doesn't bring the negligence action against a negligent third-party tortfeasor, or at least they have the option to. Great. So everybody's participated in our first question. So let's continue on. In the law, there is a legal maxim, which is like one of our core principles, that there can only be one recovery for one injury. But you might be saying to yourself right now, hold on a minute. I thought there were 2 ways that you could recover for a workers' compensation injury. And it's true, there are. You can pursue your benefits under the workers' comp statute, and you can sue somebody, a negligent third-party tortfeasor. But what you can't do is recover more than you would get from either one of those avenues for recovery, because for every injury, there's but one recovery. This is the concept that leads to all of the case law and all of the confusion that people experience about third-party actions. Because what third-party actions, what the statute is meant to do is to prevent an employee, despite the fact that there are 2 avenues for them to get money when there's a workers' comp injury and a negligent third party. They can only get one recovery for those injuries. So the rest of the statute, after it gives the person the right to pursue those 2 avenues for a recovery, the whole rest of the statute is pretty much about preventing 2 recoveries for that one injury. So let's take a look at that. This is reiterating pretty much what I just said. Section 29 allows for the 2 paths for an injured employee to get compensation for a work injury. So I want you to think of work injury as the actual injury that the employee sustains while at work, not as the workers' compensation claim, but for any injury that happens at work, okay? So we're going to think about the work injury as having a value, and there are 2 ways that you can get the value for that work injury when there's a negligent third party. There isn't always a negligent third party, but when there is a negligent third party, you can file for your workers' compensation to get the value for your work injury, and you can bring a third-party action to get the value for your work injury. What you can't do is keep the recovery that you get from your workers' compensation claim and the third-party action together. Slide.
So it's basically just one bowl of ice cream with 2 different spoons.
Pretty much, yeah. So when a claimant receives the one recovery, one injury can be distilled as what the claimant receives from a workers' compensation claim and from the third-party action together cannot exceed what would have been received from either injury alone. And that is because you can only get one recovery for one injury. So I'm probably going to say that about 27 more times today. It's a very important concept, not simply in understanding liens and credits, but then eventually in understanding how we apportion attorney's fees, which is going to be the subject of our next presentation, among other things. Okay, so just remember that. One recovery, one injury. So what you get from the comp claim and the third party together cannot exceed what you would have received from either path for recovery alone. Slide. So let's take a look at an example. Okay, so for example number 1, we have a work injury. Okay, again, think of the work injury not as the workers' compensation claim, but an injury that happened at work. And there happens to be a third-party tortfeasor. So you can pursue your workers' compensation claim, and you can pursue the third-party claim. Let's, in this example, assume that under the workers' compensation claim, the employee is entitled to $250,000 in medical benefits and indemnity benefits. That's the total value for the workers' compensation claim. On the third-party action, the injured worker was entitled to recover $1 million. Okay, so the question is, what's the value of the work injury? Slide. Since the employee cannot recover more than you get one recovery for one injury, the full value of this work injury is $1 million. You cannot exceed the full value of the third-party recovery in this example because the third-party recovery is the larger of the 2 paths for recovery. So if a work injury's value is $1 million, that's the most it could be. The reason there's an angry face here is because the claimant can't keep $1 million from the third-party action and $250,000 from the workers' compensation claim because that would not be one recovery for one injury. That would be 2 recoveries for one injury. So this is an unhappy example here. We'd have to do something in this situation to rectify what is called a double recovery. We need to get it back to that one recovery for one injury. The question is, how do you do that? Slide. I'm going to reiterate. What a claimant receives from the workers' compensation claim and from the third party together cannot exceed what would have been received from either action alone. Pursue both paths for recovery, that's fine. But you can't keep both recoveries if it exceeds the value that you would have received from either action alone. One recovery, one injury. Slide. So to make our previous example a satisfactory example, if we could reduce the third-party recovery in some way by the value of the workers' compensation claim, now we have one recovery for one injury. If the workers' compensation claim and the third party together do not exceed the $1 million that the work injury has in value, then we have avoided the situation of a double recovery. There's one recovery for one injury. And most of third-party questions arise out of how do you reduce the value from the third-party recovery from the $1 million that the claimant got down to $750,000 so that there's one recovery for one injury. Slide. Let's try another example because the concept of work injury value is very important. Here's our example: is the work injury is worth what? We have a workers' compensation claim that's worth $250,000. There's a surgery involved, there's an extended period of lost time, there's ultimately a classification with the claimant entitled to a certain number of weeks for a permanent partial disability benefit. So the workers' compensation claim is fairly expensive. It's worth $250,000 to the claimant over the lifetime of the claim. But there's also a third-party action against a negligent tortfeasor. Imagine a motor vehicle accident, and frequently motor vehicle accidents have $50,000 limits on policy recoveries under the required coverage that you have to have as a motor vehicle to insure a motor vehicle in New York. So let's assume that the recovery from a third-party action is $50,000, and that's the limit of the policy. So the question here is, what's the value of the work injury? Workers' compensation claims worth $250,000. The third party is worth $50,000. Well, you guys are going to tell me. Slide. What's the value of the work injury in our previous example?
A, $250,000.
B, $50,000.
C, $300,000.
Or D, $200,000. Again, please text your answer to the number 22333. 250, 50, 300, or 200. And we can see your answers coming in, hopefully. Terrific. All right, let's see what our answer is. The value of the work injury where the workers' compensation claim is worth $250,000 and there's a recovery from a third party of $50,000 is, as most of our respondents knew, A, $250,000. Okay, again, think of the work injury as the injury that happened at work, not the workers' compensation claim. In this instance, the workers' compensation claim is worth $250,000. The recovery from the third party from the motor vehicle accident is $50,000. Together, the workers' compensation claim and the recovery from the third party action cannot exceed the value of either action alone. The workers' compensation claim is the more valuable of the two paths for recovery, and so the maximum value for the work injury, because there's only one recovery for one injury, is $250,000. Great. Okay. Let's try another. So here's our angry face again, right?
He's
so, he's mad. Should have had a MAD 3 with us. So our work injury, what's the value of the work injury? Well, it's what we just discussed. The value of the work injury, the full value of the work injury, ends up being the same as the full value of the workers' compensation claim, $250,000. So the $50,000 from the third party, the claimant can't keep that $50,000 from the third party action and take all $250,000 in workers' compensation benefits, because if he did, he would be getting $300,000 or a double recovery. So the most that the claimant can get from this example, where there's a workers' comp injury of $250 and a third party of $50, is $250,000. Again, how do we accomplish that? Well, let's take a look at a possibility. Because again, what a claimant receives from a workers' comp and the third party together cannot exceed what would have been received from either action alone. So to rectify our previous scenario, where the claimant was getting both the $250,000 in workers' comp benefits and the $50,000 in benefits from the third party. Slide, please. If we could reduce what the claimant receives from the third party to zero, then you avoid the double recovery. The claimant gets all $250,000 in workers' compensation benefits. That matches the full value of the work injury, and so now there's only been one recovery for one injury. Hopefully this is making sense. If not, we're going to try some more examples to see if we can bring it home. Slide. All right, so the way that we prevent double recoveries aren't by smiley faces. The way we prevent double recoveries are by lien recoveries and credit or offset or holiday rights.
So the lien recoveries are from past benefits paid, and the credit or offset or holiday rights are from your future liability.
Yeah, people don't know this, but I have a cattle prod here at the office, and if any of my attorneys refers to a past benefit on a third-party action as a credit, I zap them.
Yes.
And now, going forward, I expect everybody who's now listening to this presentation, you will know more than 90% of all workers' compensation practitioners in New York State if you learn that lien recoveries for carriers or employers apply to recovering benefits that have been paid in the past at the time of a recovery on a third-party action, and a credit or an offset or a holiday, I don't care which of those terms you use, as long as you're referring to the benefit that the carrier or the employer gets against future workers' compensation benefits that they would otherwise have to pay. So we're going to drill this into everybody's heads too. Liens apply to the past. Credit, offset, holidays applies to the future. Slide. Section 29 is also the section that provides for liens and credits, or liens and offsets, or liens and holidays. So there are two types of compensation benefits which are considered at the time of a third-party recovery to ensure that a claimant doesn't get a double recovery. Benefits that were paid in the past by the carrier or the employer, and benefits which will have to be paid in the future. Past equals lien, future equals credit, offset, holiday. All right, so we're going to prevent double recoveries by giving the carrier a lien against the recovery for benefits which have been paid in the past, and we're going to give the carrier or the employer a credit, offset, or holiday against benefits which will have to be paid into the future to prevent a double recovery for benefits that are due or will be due. Slide. We're going to talk specifically about past benefits now and lien rights. To prevent a double recovery at the time of a third-party recovery, for past benefits paid on a workers' compensation claim, the carrier or the employer is given a lien against the recovery for benefits already paid. So what does that lien mean? It means that the carrier or the employer gets repaid for the benefits that they've already paid. So that's where we're taking money out of that third-party recovery and we're giving it to the carrier, and that prevents a double recovery by the claimant. Slide. I'm not keeping up with my presentation here. Future benefits and credit rights. That's how we prevent a double recovery for benefits that the comp carrier would have to pay in the future. So at the time of a third-party recovery, the claimant puts some money in their pocket. Well, they can't then continue to get workers' compensation benefits, because if they did, that would be that double recovery that we do not want to violate that maxim. For one injury, there's one recovery. And so therefore, the carrier is relieved from having to pay for benefits until the credit or the offset or the holiday from the third-party action, the money that the claimant put in his pocket, is offset, is gone, is no longer sufficient to pay for the benefits that the carrier would have otherwise had to pay. Let's take a look at some examples.
And I know we'll talk about this next month, but when you sign the consent for settlement, then that takes effect the date of the consent letter.
Yes, it does. That's very important because you don't want to continue to
Pay.
have benefits get paid because then they won't be accounted for in your lien. They'll no longer. What you do is if you don't start taking credit right away, it becomes lien, right?
Yes.
Okay, so which of the following are true? 1, a credit is meant to address workers' compensation benefits to which the claimant was entitled in the past, and a lien is meant to address workers' compensation benefits to which the claimant might be entitled in the future. 2,
Credit for past payments is meant to address workers' compensation benefits to which the claimant was entitled in the past, and an offset is meant to address workers' compensation benefits to which the claimant might be entitled in the future.
3, holidays affect future workers' compensation benefits.
And 4, liens address past workers' compensation benefits.
So please, again, text your response to 22333, not 222333. TO 22333. Is your answer A, none of the above, B, all of the above, C, 2, 3, and 4, or D, 3 and 4? Great. Let's see what the answer is. Answer is D, 3 and 4 only. Okay. The reason why A and B were incorrect, can we just go back to the previous slide, please? Okay. Number 1, a credit is meant to address workers' compensation benefits to which the claimant was entitled in the past. No. Credits apply to the future. Okay, and then the second part of that is a lien is meant to address workers' compensation benefits to which the claimant might be entitled in the future. No. Liens address the
Past.
2 is a tricky one. 2, a credit for past payments is meant to address workers' compensation benefits to which the claimant was entitled in the past. Well, it sounds reasonable, right? Except that, what do credits apply to?
The future.
The future, right. So don't let terminology like that, don't get sloppy with terminology like that. That this is exactly what plaintiffs' attorneys do and what claimants' attorneys do because they don't understand it. So like I said, you guys now understand this stuff better than 95% of all workers' compensation stakeholders. By the end of the presentation, you're gonna know more than 99%. A credit for past payments, there's no such thing. Okay, there's a lien for past payments. A credit only applies to future benefits. Same thing with holidays and offsets. And then 3, holidays affect future workers' compensation benefits. Well, that's true. So do offsets and so do credits. And 4, liens address past workers' compensation benefits. Yes, liens address payments already made at the time of the recovery. So the correct answer was D, 3 and 4 only. Thank you. Let's move on.
That was a good answer. A lot of people got that one right.
Yep, that was great. Okay, liens and credits. Many times at the time of a recovery, a third-party recovery, there's a carrier or an employer is going to benefit from the third-party action. And I'm just going to throw the term benefit in there right now. But I want you to start thinking about who's benefiting from the third-party action. But many times at the time of a third-party recovery, a recovery from a third-party tortfeasor, the carrier or the employer has already paid for some benefits, and we know that there's going to be an obligation for the employer or carrier to continue to have to pay benefits into the future, but for the third-party recovery. Right? So at the time of the third-party recovery, there's definitely some benefits which have already been paid on the comp claim, and there's an entitlement to future payments on the comp claim because the claimant, as we know in New York, is entitled to lifetime medical benefits. And if you can demonstrate that you have causally related reduced earnings in the future and your cap hasn't run out on your PPD benefits, there's going to be an entitlement to future benefits as well. What's the only time, Melanie, that there would be no future benefit?
The 32 agreement?
Yes, exactly. So when a claim has already been settled by way of Section 32 agreement and you get the recovery from the third-party action, hopefully You had good defense counsel who reserved your rights, your third-party rights in the Section 32 agreement, but at the time of a recovery on a third-party action where there's already been a 32, the only thing you could ever have, if it was a full and final, would be a lien recovery, because there is no future entitlement to any benefits on the workers' compensation claim if it's a full and final 32.
And there should be language in your agreement that this is not a, the claimant has to indicate that he does not have a lawsuit pending or no known future plan to do so.
Right. Or you have to acknowledge that there is a third-party action,
Yes.
and you're reserving your Section 29 rights. Your Section 29 is both your lien and credit rights are in there, because the failure to do so could amount to a waiver. All right, so liens and credits. As I said many times, at the time of a recovery, a third-party action recovery, there is the carrier's already made payments, and there is an expectation that they will have to make payments in the future. So you have to both have a lien recovery to prevent the double recovery for the benefits the claimant's already received in workers' compensation, and you have to determine the amount of the credit to prevent the claimant from receiving workers' compensation benefits while they're enjoying the money that they received from the third-party action. Slide. Let's take a look at an example where at the time of a third-party recovery, there is both a lien that the carrier will be entitled to out of the third-party recovery, and there will be a future credit against benefits. At the time of a $1 million settlement, the carrier has paid $100,000 in medical and lost wages.
The claimant's future lifetime benefits at the time of recovery are valued at $150,000.
So again, this is a $1 million settlement, so $1 million recovery from a third-party tortfeasor. There's already been paid $100,000 in medical and lost wages, and the benefits in the future are valued at $150,000. And imagine, that's the entire workers' compensation claim, right? The benefits that have already been paid and the future value of $150,000. Slide. Here's your question. First, what is the full value of this work injury?
At the time of the $1 million settlement, the carrier has paid $100,000 in medical and lost wages.
And the claimant's future lifetime benefits on the workers' compensation claim are valued at $150,000. Is the full value of the work injury A, $1.1 million,
B, $250,000,
C, $1 million,
and D, $1,250,000?
Again, think of the work injury as the injury that occurred at work, not the workers' compensation claim, not the third-party action. It's what is the full value of the injury that occurred at work. Please text your answer to the number 22333. Okay, let's see what people have answered. Oh, sorry, we still have answers coming in. Just a moment, I want to acknowledge our production crew, Max Dolden and Justice Williams. They are amazing.
They are amazing. What is that? Head scratcher.
You know the answer?
Yeah.
Okay. Are we having some technical difficulties? So if you're having difficulty getting your answers through, then you may need to re-log into our service, which is called Poll Everywhere Software. So you may need to, I guess we've had some technical difficulties. So if you can text Melissa Day 929 to that same number again, 22333, then we'll get you going again and being able to answer these scintillating questions. Great. $1 million settlement, $100,000 already paid in comp for medical and lost wages. Future benefits will have to be paid of $150,000. The value of the work injury, A, $1.1 million, B, $250,000, C, $1 million, or D, $1.25 million. What's the answer, Melanie?
B.
What?
C.
100%. Terrific. Correct. The full value of the work injury happens to coincide with the full value of the third-party action in that example. The third-party action was worth $1 million. The comp claim was worth $250,000. Full value of the work injury, the injury that occurred at work, is $1 million. You get one recovery for one injury. So the most that this one injury could get this individual is $1 million. Same example, we're going to ask another question now.
What is the full value of the work injury?
Okay, that's the same. That's the same question. We're looking for question 5.
What is the carrier's lien recovery?
You got $1 million settlement. The carrier has already paid $100,000 in medical and lost wages, but the carrier would have to pay in the future $150,000. What's the carrier's lien recovery on $1 million settlement? A.
At the $100,000.
B. $250,000.
C. $150,000.
Or D. None of the above. What is the carrier's lien recovery? Text your answer A, B, C, or D to the number 22333. Slide, please. Suspense is killing me.
I know.
It's like, how do you keep an idiot in suspense? I'll tell me tomorrow. What is the carrier's lien recovery? It is A, $100,000. So we had $1 million third-party action recovery. At the time of the recovery, the carrier had already paid $100,000 in benefits. There is a future
credit
requirement to pay $150,000. And so the carrier's lien recovery, which addresses the past payments made at the time of the recovery, is $100,000. Terrific. Let's
Good
try another question related to the same example.
What is the carrier's credit?
Same example, $1 million recovery. At the time of the recovery, the carrier's already paid $100,000 in benefits. The claimant's future lifetime benefits at the time of the recovery are valued at $150,000. What is the carrier's credit? A, $100,000.
B, $250,000.
C, $150,000.
Or D, none of the above.
Please text your answer A, B, C, or D to the number 22333. What is the value of the carrier's credit or holiday or offset? And the answer is?
I forgot what the numbers. It's C. I knew it was 150. I just forgot what letter it was.
Which letter it was. The answer is C. Okay, the carrier's credit. The carrier will get a credit in the amount of $150,000 out of the claimant's third-party action. So if the carrier, let's go on to the next question.
Lien and credit.
So this is the answer to our example. The carrier, at the time of the $1 million recovery, recovers its lien, the benefits it's already paid of $150,000. It gets to exercise its credit of $150,000 against the remaining benefits that it would have had to pay if there hadn't been a third-party recovery. The claimant's total benefit from the third party is $750,000, and the carrier's benefit from exercising its lien and credit rights is $250,000. And not surprisingly, what is the claimant's benefit and the carrier's benefit? What do they total?
$750,000.
The carrier's benefit, the claimant's benefit is $750,000, and the carrier's benefit is $250,000, and together they
million.
add to $1 million. Right. Because the claimant actually pocketed $1 million, but remember, the claimant can't keep the comp benefits and the recovery from the third-party action. And so then the carrier benefits because the carrier is repaid its lien and relieved of the obligation to pay benefits in the future. And that's the way we prevent the double recovery. Slide. This is our lien and credit example number 2.
At the time of a $75,000 third-party settlement, the carrier has paid $100,000 in workers' comp benefits in a case that has settled by Section 32.
Okay, so we have a case where we know the value of the workers' compensation claim, right?
Mm-hmm.
$100,000, it's a full and final. That's an important detail, actually, that I should have included in our fact pattern. And then the claimant gets a $75,000 recovery from a third-party settlement. Slide. We're going to ask you some questions again. And not surprisingly, we're going to start with, what is the full value of the work injury in that example?
A, $75,000.
B, $175,000.
C, $100,000.
Or D, $25,000. It's a $75,000 third-party settlement and a claim where the carrier has already paid $100,000 in workers' compensation benefits and the claim has settled by Section 32 agreement, full and final. What's the full value of the work injury? Again, the injury that occurred at work, not the comp claim or the third party. Full value of the work injury is C, $100,000. Great. Okay, and that's because there's one recovery for one injury. So the value of the work injury is $100,000. It's the larger of the two recovery, the two paths for recovery. Remember, you can pursue comp and you can pursue your negligence action, but you don't keep both. So you don't get to keep the $100,000 that you received in comp benefits and the $75,000 that you received in third-party benefits, unless you're doing something really funky at the time of consent to settlement, but you wouldn't do that.
No.
Okay, so the full value of this work injury, full value of the work injury is $100,000. That's okay, we can go on, because what is the value, what is the carrier's lien recovery?
A, $100,000.
B, $25,000.
C, $75,000.
Or D, 0. $75,000 third-party recovery. At the time of that third-party settlement, the carrier has already paid $100,000 in workers' comp benefit, and that case has settled by way of Section 32. So there's no future on that case. There's only the past. So what is the carrier's lien recovery? 75, 100, 25, or 0? Please text your response to the number 22333. The carrier's lien recovery is, said 0%, got C at first. I was like, oh no.
It keeps doing that.
Correct. The answer is $75,000. All right, so at the time of that, the carrier gets it all, right? Because you get one recovery, one injury. At the time of the recovery from the third-party action, the carrier's paid $100,000 in benefits. To prevent a double recovery, the carrier has to take the entire third-party recovery. Or if the claimant keeps $1 of that, that means the claimant would get $100,001. That's a double recovery. Right? So to prevent the double recovery, the carrier gets the entire lien. Slide. And not their entire lien, because their lien was $100,000. Excuse me, I want to be precise about that. The carrier gets the entire recovery. The claimant gets nothing. Same example.
What is the carrier's credit?
At the time of a $75,000 third-party settlement, the carrier's already paid $100,000 in workers' compensation benefit on a case that's settled by Section 32. The carrier's credit, is it $100,000?
$25,000.
$75,000?
Or 0.
Carrier is going to take the entire $75,000 settlement in a case where it's already paid $100,000 in workers' compensation benefits. What's the carrier's credit following that recovery? And the answer is Zero. There is no credit. And that is because the carrier gets the entire recovery. The carrier is, the claimant gets nothing in a case where the carrier's lien, the payments it's already made, exceeds the value of the third-party action. The only way to prevent a double recovery in that scenario is for the carrier to take the entire recovery from the third-party action where the lien exceeds the value of the third-party action. And then because the claimant gets nothing, there is nothing against which the carrier can exercise its credit. And there's no need to, because you've already completely accounted for the any possible double recovery.
Yeah.
Slide. We're going to try another. We're just going to look first at the example that we just went through. So we have a lien and credit example number 2. The value from the third-party action is less than the total amount of the workers' comp benefits due. The value from that third party was only $75,000. The value from the workers' compensation claim was $100,000. Sometimes it happens that the workers' compensation claim is the more valuable of the two paths for recovery that an individual has when they're injured at work. Remember, they have a work injury. When there's a negligent third-party tortfeasor, they have two paths to get money. They have the workers' compensation claim, and they have the third-party action. And we're accustomed to thinking of third-party actions as being big recoveries.
Yes.
That's where you see Celino and Barnes advertising for, did you have an injury at work? Did you fall off a building? Please call us, because those are the cases where there are big insurance policies and they can get big recoveries from their clients. But a very large percentage of recoveries from third-party actions are actually small amounts. And many times, the workers' compensation claim is the more valuable of the two paths for an individual to pursue when they've had a work injury. So in a case where the value from the third party is less than the total amount of workers' compensation due, the carrier should, or they have a right to, take the entire value from the third-party action. That's the only proper way to actually prevent a double recovery, because if you let the claimant pocket $1 from that recovery, from that third-party action, then that claimant has received a double recovery. I mean, not like it's a moral failing or anything like that, but I mean, in our world, there's a maxim. You get one recovery for one injury. And so in a case where the comp claim exceeds the value of the third-party action, then the carrier should get the entire value from the third-party action. So in order to do that in this situation, in this example, the carrier has to recover the entire $75,000 of the third-party recovery. There's no credit because the claimant didn't receive anything. The carrier got the entire recovery from the third party. And the claimant's total benefit from the third party is $0. The carrier's total benefit from the third party is $75,000. So when there's a negligent third-party tortfeasor, normally the workers' comp carrier just has to pay the comp benefits, right? Mm-hmm. That's the grand bargain. The carrier or the employer is going to pay for the workers' compensation benefits. And in the normal scenario where there isn't a negligent third-party tortfeasor, the carrier or the employer is liable for paying those benefits. In a situation where there is a negligent party, what the law says is not only can the claimant pursue that action to see whether or not he can get a recovery that exceeds the value of the workers' compensation claim, but the carrier can benefit too. And that seems just to me. If there's if I, Melissa Day, I'm an employer, if somebody negligently injures my employee, then I feel like that person should have to pay for causing my employee that injury. And so sometimes if the recovery is large enough against a negligent person, then the claimant will benefit from that. The carrier will benefit from that also, because if there hadn't been a negligent third party, they would have just paid for the benefits. Yep. They wouldn't have had a possible avenue for recovery. Now, sometimes only the employer or carrier benefits because the value of the workers' compensation claim exceeds the value of what the negligent third-party person has to pay. Slide. Example number 3. I've already lost. I don't think it matters what page I'm on in my notes. All right, here's our next example.
At the time of the $300,000 settlement, the carrier has paid $100,000 in medical and lost wages.
The claimant's future lifetime workers' compensation benefits at the time of recovery are valued at $250,000. So we have an MSA, and we know what the PPD benefits are going to be, and we know that benefits into the future are going to cost the carrier $250,000. $300,000 settlement, already paid $100,000 in medical and lost wages, and there's a future obligation to pay $250,000. So you know what the first question is going to be, right?
Yes.
What?
What is the lien?
No.
Full value.
Full value. What's the full value of this work injury? $300,000 settlement from a third-party tortfeasor. The carrier or employer has already paid $100,000 in workers' comp benefits and is going to have to pay $250,000 in workers' comp benefits in the future. So at the time of the recovery, benefits in the past are $100,000. Benefits that will have to be paid in the future is $250,000. And it's a $300,000 settlement.
So A, $350,000.
B, $250,000.
C, $300,000.
Or D, $650,000. This is where the rubber meets the road.
Mm-hmm.
If people get this answer right, we're doing a good job.
I have a good feeling.
Text your answer to the number 22333. And the answer is no. The full value. Oh, no, I'm wrong.
Yeah,
yes,
I was going
right.
to say, we should probably get up now.
That's great. The student has become the master. So the answer is, what is the full value of the work injury? It is $350,000. The full value of this work injury is the workers' compensation claim, the full value of the workers' compensation claim. $100,000 in past benefits, $250,000 in future benefits. Full value of the work injury is $350,000. That's terrific. I'm so glad people got that right.
Good job.
Next slide. So let's talk about lien recovery now. What is the carrier's lien recovery in this same example? $300,000 settlement. Carrier's already paid $100,000 in medical and lost wages at the time of the settlement and will have to pay $250,000 in the future. What is the carrier's lien recovery? A,
$200,000.
B, $250,000.
C, $100,000.
Or D, nothing. At the time of a $300,000 settlement, there have already been paid benefits of $100,000, and the carrier is going to have to pay in the future $250,000. What's the lien recovery? Text your answer to the number 22333. Take it away.
And the answer is C.
Correct.
Good job.
Wonderful. Good job, everybody. The carrier's lien recovery is $100,000. The carrier recovers the benefits it's already paid in the past at the time of the recovery. So what's our next question is going to be about the credit. What is the carrier's credit at the time of a $300,000 settlement? They're going to recover $100,000, we just learned in the lien. Their future benefits are valued at $250,000. What's the carrier's credit?
A, $100,000.
B, $250,000.
C, $150,000.
Or D, $200,000. Text your answer to the number 22333. This one's a little tricky.
It is a little tricky.
Hopefully people are not sleeping in their soup. Okay, drum roll. The answer is D. Terrific. The answer is $200,000. Why is it $200,000? The recovery, or the third-party recovery, is $300,000, and the carrier got how much? From the lien recovery?
From the lien recovery, $100,000.
They got $100,000. So what's left?
$150,000. No, $200,000.
$200,000, right? $300,000 recovery. The carrier gets repaid $100,000. And so what remains from the third-party action? It's only $200,000. So the carrier's credit is $200,000. What happens after the $200,000 credit is used up?
They're back on the hook.
They're back on the hook. They're paying again. And that's how the claimant will get full value in this claim. Okay, the claimant received $100,000 in medical and indemnity benefits up until the time of the recovery. Then the claimant gets the recovery of $300,000. They have to repay the carrier the $100,000 that the claimant already received in benefits. And then the claimant doesn't get benefits again until those benefits equal $200,000. That's what he has remaining in a recovery from the third-party action. Once the claimant has used up that $200,000, then he gets back on comp again, and he's entitled to the other $50,000. That's what we call, do you know what that's called?
Deficiency?
Yes, exactly. That's called a deficiency claim, and that is when the recovery from the third-party action is deficient in being able to cover the entire cost of the work injury. Not the workers' compensation claim, but the work injury. So if it's deficient, then the carrier has to pay again once the credit is fully absorbed, once the holiday is over. Just like when vacation's over, you have to go back.
Yes.
Slide. All right, so let's just take a look at our example again. $300,000 settlement. The carrier's paid $100,000 at the time of the settlement already in medical and lost wages, so that's our lien. That's benefits paid in the past at the time of the recovery. The claimant has a future of lifetime benefits that will be owed to him, valued at $250,000. So another $100,000 in medical is what your MSA says, and you value the PPD benefits at $150,000. So at the time of the $300,000 settlement, the claimant repays the $100,000 in benefits he's already received so as to prevent a double recovery, and doesn't get benefits to the tune of or to the value of another $200,000 in benefits. And then once that's exhausted, the claimant gets to get back on workers' compensation again. A double recovery has been prevented because the claimant repaid the benefits he'd already received and doesn't receive benefits during the time that the carrier would have otherwise had to pay until such time that the proceeds from the third party are exhausted and he's entitled to benefits again. So there's no double recovery. The full recovery is $350,000. It's that simple. Slide. So revisiting the idea of benefit from third-party actions, we just touched on this about 5 minutes ago. Okay, when there is a negligent third-party tortfeasor on a workers' compensation claim, the claimant or the carrier can benefit from a recovery. Okay, so if the value of the third party exceeds the value of the workers' compensation benefits, then both the claimant and the carrier can benefit. So that's our $1 million Salino and Barnes recovery, right? When there's $1 million recovery from a negligent tortfeasor, that in all likelihood will exceed the value of the workers' compensation claim. And if that's the case, then both the claimant and the carrier are going to benefit. The carrier benefits because there's a third-party tortfeasor which is paying part of the benefits that the carrier would have otherwise had to pay alone without any source of recovery in a workers' compensation claim where there's no negligence, where there's no negligent third party that instead of Melissa Day saying like, okay, I have to pay the benefits, but wait, this person was negligent and hurt my employee. In a situation where there is another party, then I can benefit and the claimant can benefit if the value of the third-party recovery exceeds the value of the workers' compensation claim. Now, this is the real trippy mind kind of screw here, but if the value of the third-party recovery is less than the total amount of the workers' compensation claim, then only the carrier benefits. Really, what the claimant is doing is when they get a third-party recovery where the recovery is less than the value of the workers' comp claim, is they're basically just buying time from the carrier where the carrier doesn't have to pay until the carrier has to pay again, right? So like they get some benefits for a period of time, they get the recovery, they have to repay those benefits, and then the carrier doesn't have to pay for a period of time, but eventually the carrier does have to pay benefits again. In that situation, the claimant doesn't really benefit from the third-party action. I mean, they pocketed a lot of money and basically got an advance on their workers' comp benefits. But ultimately, if the value of the workers' compensation claim exceeds the value of the third-party recovery, only the carrier benefits from the third-party recovery. This is an important concept to understand.
Have you seen much of carriers actually exercising their subrogation rights?
Their subrogation rights?
I mean, their rights to
the full
subrogated,
recovery?
Yeah.
Absolutely. And if they come to us, we recommend that they take a hard line. Frequently claimants third-party attorneys, so the attorney on the third-party action, they will come to the carrier and say, like, well, you should waive part of your lien, or you should not take a credit against the recovery that we're trying to get for this client, because you know what, there's a good chance that we'll get no caused if we try and take this to trial. So basically what they're saying is that the carrier should compromise and should either give up part of what they're entitled to recovery in lien for benefits already paid, or they shouldn't exercise their credit rights into the future, and they should basically allow the claimant to get a double recovery. Right. And the rationale is always like, well, if you don't agree to do that, then there's a chance that you could get nothing. And you know what? If there's a chance that the carrier can get nothing, guess who else could get nothing?
Them.
Right. And their client. Right. So there are ways to deal with that situation when that arises, but I never recommend to a client that they negotiate from that position at the outset. You always want to take a hard line and say, no, I have a statutory right to a lien recovery and to an offset, and that's what I want. And it frequently inures to your benefit to take a hard line like that. Slide. The reason I want everyone to keep in mind who's benefiting from the third-party action is that when we talk about apportionment of attorney's fees, it's an important concept to keep in mind so that you understand who should have to pay for what. All right, that's where things get really kind of complicated in third-party actions. I mean, it's one thing to talk about lien recoveries and credits when there's no attorney involved, but of course, once the attorneys get involved, everything gets complicated because the attorneys want their piece of the pie. So if you can keep your mind on and keep your focus on who's benefiting from this recovery, that will help you decide who should have to pay for the attorney's fees. You should have to pay the attorney's fees based on the benefit you receive. So if a claimant gets nothing, gets no benefit from a third-party action, who should have to pay for the attorney's fees? The carrier. Okay. So it's not unreasonable to ask a carrier to pay full value for all of the fees associated with a third-party recovery if the value of the workers' compensation claim exceeds the value of the third-party recovery, because the entire benefit from the third-party recovery is going to inure to the carrier's benefit. Let's just talk about our example 3 again. $300,000 settlement, carriers paid $100,000 in medical and lost wages, so that's characterized as their what?
Their lien.
Their lien. Okay, past benefits paid at the time of recovery, that's your lien. The claimant's future lifetime benefits at the time of the recovery are valued at $250,000. That is the potential value of the credit. However, in our scenario, there's only $200,000 left from the recovery. $300,000 minus lien recovery of $100,000 equals $200,000. And so the carrier's credit can only be as much as the full rest of the value of the third-party recovery, so it's $200,000. Once that credit is exhausted, the claimant then again becomes entitled to workers' compensation, and in our scenario would be entitled to another $50,000 in benefits. Slide.
Question 13. What is the full value of the work injury?
Seems like we did it. Well, can't hurt to revisit it. So we have $100,000 in past workers' compensation benefits paid at the time of a $300,000 recovery. The future value of the workers' compensation benefits is $250,000. There has been a $100,000 lien recovery and a $200,000 credit. What's the full value of this work injury? A,
$100,000.
B, $200,000.
C, $350,000.
D, $300,000. Let's see if I can get it right this time. Text your answer to the number 22333. A, 100, B, 200, C, 350, or D, 300? And the answer is full value of this particular example is $350,000. The work injury being the injury that occurred at work. The workers' compensation claim is worth $350,000. The recovery from the third-party action was only $300,000. So full value for the work injury is $350,000. Okay, I feel like that horse has been beat sufficiently.
How much did the carrier benefit from the third party?
Same example, $100,000 in past benefits paid at the time of the $300,000 recovery. The future value of workers' comp benefits is $250,000. Carrier gets a $100,000 lien recovery and a $200,000 credit. So how much did the carrier benefit from the third party?
A, $100,000.
B, $200,000.
C, $350,000.
Or D, $300,000. Text your answer to the number 22333. And the answer is D, $300,000. So the carrier got the entire benefit from the third-party recovery. They got that by lien recovery of $100 and credit of $200. And there's nothing left really for the claimant. So the claimant did pocket $200,000 after he repaid the lien, but ultimately those benefits went as a prepayment of the workers' comp benefits that he was otherwise entitled to receive. And once those benefits covered the cost of those workers' comp benefits, the claimant had exhausted all of the third-party proceeds and became entitled to workers' comp again. So really, the claimant didn't benefit from that third-party recovery at all. Fine. How much did the claimant benefit from the third party? A, 0.
B, $100,000.
C, 200,000.
Or D, $300,000.
Text your answer to the number 22333. A, B, C, or D. What was the claimant's benefit from the third party, where they had a $100,000 lien repayment and a $200,000 credit? Correct answer is A, 0. The claimant received no benefit whatsoever from the third-party action because those benefits, the third-party recovery repaid the carrier's lien and ended up being a credit against benefits to which the claimant was otherwise due from the workers' compensation claim. So the claimant received $0 in benefit ultimately from the third-party action. So they basically pocketed that money for a while, but they really just got an advance on the benefits that they were otherwise going to be due, that they were entitled to. And once they'd paid out all that money to cover benefits that they were otherwise entitled to, they fully exhausted the third-party recovery, and they really got $0. And I'm sorry we've gone over, but I think we're just about done. Okay, attorney's fees, we're going to be looking at who pays for the benefit. We've already discussed the possibility that if the carrier receives the entire benefit, the carrier should have to pay 100% of the fees. And we're going to get into this in far greater depth on part 2 of our presentation next month. Slide. Getting traction on third-party actions will be continued. It'll be March 24th, I think, exactly 4 weeks from today. Is that what we've decided? Okay. Mm-hmm. And at that time, we're going to be talking about some of the seminal decisions, both Kelly and Burns, and hopefully we'll be touching on some additional issues. So please bring your smartphones again next month. We're going to make it interactive. It probably would be a good idea to bring a piece of paper and a calculator as well. Thank you very much for joining us today. If you have any questions, feel free to reach out to us. Share our webinars with your friends. Let them know that we'd be glad to have additional members in our audience. And otherwise, we'll see you next month.
Thanks a lot
for tuning in.